I think we should start. My name is Sean Jacobs. I'm the director and a professor in the graduate program of International Affairs here at the New School. And we're co-hosting this event with Rosa, Luxemburg Stiftung. And my job is just to say welcome to the New School, especially to Wolfgang. We're looking forward to hearing from him on this very important topic at a moment where we are sort of punctured by the headlines around human rights, the kind of the regime of human rights and how it is being conducted. I mean, you wake up and see that the Trump administration rendition, I don't know if that's a word, a group of Venezuelan prisoners, sending them into this bizarre kind of Kafkian experience where this video is on the next morning, the video is on YouTube. But in any case, so just a little bit about our program. We started in 2001, and the history of the program is that it started as a response to the politics of the war on terror. So tried to make sense of that world to create an international affairs program. There are a number of others here in the city. I won't name them with various other different reasons why they exist, but our initial intention was to make sense of international politics within the context of the U.S. government's war on terror. And then after 2000, where there was another reckoning in the U.S. around police violence, we began to revisit some of the debates and arguments as to why we existed. And we decided to focus now on other questions, particularly around decolonizing international affairs, which is why I think tonight's topic is really appropriate. So I will just say thank you very much for coming. Welcome. I'm looking forward to the discussion, and I wanted Stefan to just welcome everyone on behalf of Rosa Luxemburg. Thank you.
Thank you, Sean. My name is Stefan Liebig. I'm the executive director of the Rosa Luxemburg Stiftung's New York office. For those who don't know the Rosa Luxemburg Stiftung, we are a German-based non-profit, taxpayer-funded, progressive educational institute. And I am proud to introduce our guest of honor and keynote speaker, my friend Wolfgang Kaleck from Berlin. Wolfgang Kaleck is the Secretary General of the European Center for Constitutional and Human Rights. The ECCHR is an independent non-profit legal and educational organization dedicated to enforcement of civil and human rights worldwide. It was founded in 2007 by Wolfgang Kaleck and a group of international human rights lawyers to protect and enforce the rights guaranteed by the Universal Declaration of Human Rights, as well as other human rights declarations and national constitutions. Wolfgang is a litigator, but not only this, he's also an author. He writes books, and this is his last book. The name is titled Concrete Utopia. So I really recommend this one. And but what I love most about Wolfgang is that he's a really brave man. So he has stood up to governments among others, Bashar al-Assad, Syria, George W. Bush, United States, Argentina, and Germany, and others, where and when necessary. And I will only mention the actions against the German government regarding the arms exports to Israel. We are now living in a world where it is no longer enough to point out the double standards, what is our topic tonight, but to defend the few standards that still exists. And since the organization ACCHR was founded around the Universal Declaration for Human Rights, I will just quote Article 1. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards another in a spirit of fraternity. I think the world would be a better place if governments and corporations and all the people would act in this spirit. I'm glad that you are all here. I'm glad that Wolfgang is here, and I thank you very much.
Thank you very much, Sean and Stefan, for this introduction. It's fun So my name is Sakiko Fusudafar. I'm professor of international affairs at the New School here. I'm a colleague of Sean, and I'm here to moderate this conversation with Wolfgang Kaleck. So I don't think it's necessary really for me to explain what the topic is, but just to say that I think this is one of the most important moments, but also one of the most important issues, because, you know, when we have international norms, it's not just important to write them down. It's also important how it is implemented or not implemented, and who implements them, for what purpose, and who benefit. And I think the egalitarian, liberating spirit of human rights is all about that, how it is actually implemented, and the power structures that are shaping the way that that the implementation takes place is what makes the basic principles actually meaningful. So please, Wolfgang, please share with us your views on this topic.
Thank you very much, and hello everybody. First of all, thanks to Sakiko and Sean and the New School, and I'm really honored to speak at the school where Hannah Arendt taught. And thank you very much, Stefan and Rosa Luxemburg Foundation. We're happy that the party which is behind Rosa Luxemburg just made it into the new parliament with 8.8%. And the city I'm coming from, Berlin, this party is the strongest party. So that's a nice take. I mean, it doesn't change the overall panorama, but it's still nice to come from a city like that. So actually, I have two speeches, a wide mixture of thoughts and facts for you. The first speech was the one we designed in, I don't know, November or even before. That's what you read on the title, the double standards in international law. But of course, it was not intended at all. It's not intended at all to just stuck in the critique of the double standards. It's a call to action. It's a call for progressive use of international law. And so, what I have in mind is a very short history of international, above all for international criminal law, and integrated in this history the progressive use of international criminal law, at least since the late 90s. But of course, the threat to what they call liberal world order and everything else puts in question I would say one of the decisive vocabulary in the title, the standards. So we were happy to criticize the double standards because we could refer to standards, although they were never accomplished. But now this is absolutely put in question by your beloved government. So let me say this. We never had any illusions about the international legal order. We never had any illusion about the US when we set up our organization, when I went into this human rights lawyering. But we had hope. And there was reason to hope because there was this reference of the Nuremberg trials against the Nazi perpetrators with, the leading lawyer Robert Jackson, a real universalist, with, the quoted Article 1 of the UN Universal Declaration of Human Rights from 1948. But we were always aware that set up the United Nations, the UN Security Council, was also to establish the power of those states who were the veto powers in that Security Council, and the whole idea behind the declarations and so on was also together with the Washington Consensus to cement the U.S.-dominated model of democracy and liberal and then more and more neoliberal economy. So it's a very ambivalent story.
But if you dive into it, and I did that for my little double standards book, you found things that are often forgotten in the official history of human rights, because they would tell you the whole story as an unbroken story of progress, of liberal values. And I mean, it started already back in 48. And I want to only quote one person, and that was the former colonial minister of the UK, Arthur Breach-Jones, who said the UN Declaration for Human Rights is a source of embarrassment. Why did he say that? Because at the same time, while these powers who happily defeated the Nazis were and promised to now organize the world in a different way, were leading war against the liberation movements in their colonies. And so what was originally intended, the declaration is just a declaration, but binding treaties should immediately follow afterwards. And mainly because of the UK and France, they didn't work. They weren't put into force until 1966, because they rightly feared that all the war crimes and crimes against humanity they committed in Congo, they committed in Kenya, they committed in Indochina and elsewhere, all these crimes could be held accountable when these covenants, which later were put into place, would have already been integrated into the legal system. So, the ambivalence is basically accompanying the whole story of international law and of international criminal law. And I mean, I can only recommend this recent movie, soundtrack of the coup d'etat. It's a crazy good movie on the assassination of Patrice Lumumba, mixed with exciting scenes of New York, of Harlem, where Patrice Lumumba meets Fidel Castro, and you see scenes from the UN. Then we get a flavor of that time. You get a flavor that there was a non-aligned movement which was fighting for liberation from colonialism, but was also then later on, and I come back to that, fighting for a new economic world order. So the missing piece of decolonization, the until now missing piece of decolonization. So we can go through the decades, we can go through the years, and that is something I'm always reiterating. You might ask, why is this stuck in the 50s, in the 60s, in the 70s? Because it's necessary to remind ourselves that the world was never in order. There was no order. Probably there was an order, for us here in New York, in Berlin, and elsewhere. There were no wars. Your country was leading wars. Mine, fortunately, not really, but we never felt it. But in other parts of the world, I just mentioned mass murder of communists in Indonesia. I mentioned Vietnam. And later on, of course, 1973, Pinochet coup, Argentina coup, Nicaragua, El Salvador. And that's only the incidents, the international crimes this country was involved in. But one has to say, there were people here, not only Robert Jackson, but also Telford Taylor and Benjamin Ferencz, who upheld the universal principles. Telford Taylor wrote this book, From Nuremberg to Vietnam. So these people had in mind that the Nuremberg principles should be applied to the leaders of the U.S. in the Vietnam War, and they should be held accountable. So there were always these voices coming from the U.S. as well. So as you rightly reiterated, Sakiko, it's not the standards I refer to in international law is on one hand, of course, the legal standards, and the legal standards have been developing over the years, 1948, 1966, and later on all the binding conventions and torture and so on. In forums, fora are needed, and in international law, the foras have come up lately, only in the 90s, the International Court for Yugoslavia and for Rwanda. And later on in 1998, the International Criminal Court, but they need also actors who enforce these rights and who and bring cases to courts. And that was for us, I would say, the moment was the moment of enlightenment. The moment the call to action was in 1998, October 1998, the arrest of Augusto Pinochet, the former Chilean dictator in London, which, is attributed to the investigative judge in Spain, Baltasar Garzón, and rightly so. You need also courageous judges, ambivalent in all this trajectory, but still. But it was due to civil society, and to civil society actors from Spain, civil society actors from Argentina, exiled Argentinians, and later on Chileans, communities, torture survivors. And that was the moment when international criminal law was no longer an affair between the states. So, the Hannah Arendt critique, Eichmann in Jerusalem, the Israeli state is orchestrating the trial against Eichmann, is applicable to all these international criminal trials by the time. It was the states and the victims, the perpetrators, the witnesses. They played a minor role. But from 1998, things have changed, and that brings me
to this country again, and that was then my moment of entry into this. I started with the Argentinian dictatorship, but my organization basically was founded because of our commitment in the Rumsfeld cases, so the torture cases against Donald Rumsfeld, his lawyers, Dick Cheney, and all the others. And the claim was from Pinochet to Rumsfeld. And that is the kind, when I say progressive use of international law, that's what we had in mind. Apply international law in one case, and that was the Pinochet case, that was the precedent, and then try to universalize this experience and applied it to Rumsfeld. And it actually, people would, and then we claimed it, of course, law versus power, law versus the powerful actors. And it was very interesting because even the human rights scene, important human rights organization, criticized these cases against Rumsfeld. They were saying, if you go against these powerful actors, they will bash the law, they will destroy the law will be reversed. This did not happen. It happened the other way around. They took it serious. Rumsfeld and others didn't come to Germany while the cases were pending, and later on the CIA released a warning to more than 500 of their agents not to travel to several West or European countries where they feared to be held accountable. So from Pinochet to Rumsfeld, but moreover, we went on from Pinochet to Rumsfeld to Mercedes-Benz and to Nestle. Mercedes-Benz because of the killing of trade unionists during the dictatorship in Argentina. Nestle because of the killing of trade unionists in Colombia. And that is in a way accomplishing a critique of Marco Boutois, Anthony Angie, and the others from third world approaches towards international law, and above all, the very, very strong critique of Marco Boutois, framing Western human rights actors, in a way with the victims, perpetrators, saviors paradigm. So the Western human rights actors define one group as the perpetrators, the other group as the victims, and the role they reserve for themselves is the role of the saviors. And so not at all talking, not addressing at all their own complicity, that not at all in taking into account how many of the causes of major crimes in other parts of the world were set, how many dynamics were started in the northern hemisphere. And so that was also quite interesting. I can go into details later on. The interesting thing was, although we didn't win the cases, it was the first time these stories were told to a broader public in the countries where the Mercedes-Benz managers, the Nestle managers come from. They were sitting in their provincial towns
and being the Rotary Club presidents, the tennis club and golf club and museum sponsors. And now we have become and accuse them of mass murder, of rape, and torture. And it hit them. It made them nervous. And so we think, and again, I will go a little bit more into details. And lately, in Binneschet, to Rumsfelder, to Mercedes-Benz and Neste, in the last couple of years, we also included in our portfolio colonial crimes. Namibia, we addressed the genocide against the Herero and Nama by the German Kaiserreich in Namibia, which was also quite interesting because we were arguing that under today's laws, this case of genocide against the Herero Nama would be a case for the International Criminal Court in The Hague. So it was absolutely stunning to sit down with all the museum people and, the established Stiftung Preußischer Kulturbesitz and others who were sitting on the raw artifacts of colonial times and telling them, reading to them words from post-war politicians like Filbinger, who said what was right by the Nazi times cannot be unjust by this time. So I read that to them, and then I read to them the legal writ the German lawyers filed here in this city, in New York, again defending themselves against the Herero and Nama reparation complaint, and using basically the words of the time. And they feel ashamed. So that is something I'm going to repeat more and more. They always thought that the legal field is theirs. Lawyers were serving the elites. Law was never really democratized. And so that is something where they feel vulnerable. Although, and that's then my next, let's say, subtitle from litigation to intervention, it's very clear. We never said we're going to heal the world. I mean, litigation is not a solution. Litigation can disrupt. Litigation can contribute to social and political struggles. It's a tool of critique. It brings actors who haven't been heard the public fora. Again, but when it comes to real material struggles, it's very clear. There is a complete power balance, and you see it above all in the cases against the companies. I mean, the moment you file a case against a major company, and you work with, let's say, 2 or 3 lawyers, which is a lot, they will throw in 100 lawyers and a million budget for public outreach and to buy legal experts and other experts to support the case. So it means that because of this power and resources imbalance, it means that we have to be creative, inventive, flexible, and we have to produce the momentum all the time. Means not overestimating, but also not underestimating legal tools. And there's this one critique in particular when it comes to business and human rights, and that is, okay, you are only focusing on the excesses, when people were dying, people were tortured, but you're not addressing the daily injustices of global capitalism. It's partly right. It's difficult to tackle inequality and global injustice, the global the completely unjust global trade relations, the economic order, and everything else. Of course, the new economic world order is still missing. But on the other hand, these cases allow us to make a point. So, and that's what I framed. You quoted to my book, Concrete Utopia. Yeah, that's the concrete utopian approach. We start in the here and now. So we file cases in the here and now, but we use then the feeling. We use the public sphere to bring up much broader systemic and structural critique. That sounds all nice. It is to some extent also a nice development, but it's contradictory, obviously, because on one hand you have a very vivid and dynamic scene using international law, using human rights law, and you have people here like Samuel Moyn, and others who are criticizing, rightly so, Western actors, Western human rights. And
Can you just back up a bit like explain a bit more the you talking about cases? Can you illustrate with a case that did this that you used a case to illustrate the structural problem?
yeah. Factory fire 11th of September in 2011 in Karachi, Pakistan. More than 200 workers burned in that factory.
Garment factory.
Textile factory. And so we were called there because German organization Medico International was involved. And so they called us immediately. So a colleague of mine goes there. And so first of all, we have left already long ago this paternalistic approach. We bring justice here with barbarians. How? Yeah, no, I mean, because that's not me. We bring, and there was and there is still this paternalistic approach. We know about law, we know about justice, and we bring you law and justice. But it's, of course, was never our intention. And if it was, we were contradicted and it helped and learned a lot from local actors. So the Pakistani, when we went there, my colleague went there, we said, okay, so the German company was producing the textiles mainly in that fabric which went down. And so our idea was a reparation case in Germany against this company. And the Pakistani actors said, hold on. So they said two things. One is, first of all, we meet you here. We want you to support our cases and our justice system. And that is something you have to learn. You have to learn. And that is something I just pointed to Samuel Moyn and others who were criticizing Western human rights actors. But, they didn't lynch at, so they criticized them for not enforcing economic and social rights, for ignoring them. But, they would only talk about the capitals of human rights as they phrase it, and the capitals, that's New York, that's London, that's The Hague, and that's Geneva, meaning Strasbourg. And they are not at all mentioning, and that's a typical thing for, let's say, Western mainstream law. For many of the Western mainstream law professors, they're not mentioning the right to food cases, the Supreme Court of India. They're not mentioning the right to water cases on the Supreme Court of South Africa. They're not mentioning the very important rulings of the Inter-American Court of Human Rights, and so on. So that's the one thing. These people are acting in their countries, and what we're doing is complementary. And it's a strategic decision, a strategic discussion which we need. Where should we start, and what's the next step? So we started in Pakistan, supporting the Pakistani criminal cases against the direct perpetrators, those fabric owner and those who were responsible for security. And also they said, hold on, reparation case at a civil court, wait a second. We tried to bargain with the company. So what happened was then good cop, bad cop. They were bargaining and they got money. We got, 5 million, which is not a lot. But having said that, it's very ignorant, because for the feminists, it was a lot, and it was incredibly important. At the same time, when they were bargaining, we were litigating in Germany. So we were the bad cops. And that was also very interesting, because the case itself, we lost on I should be a lawyer. I am somehow a lawyer. It's about the limit of the statute of limitation. Very difficult to explain. I'm not sure if I recall it by heart. But anyway, we lost on a stupid legal argument, but the case was incredibly successful because we brought the family members of those who burned down, and you can see their development. Their rights from, helpless mother crying in the camera and saying, my son died and we was the other one who brought money for the funeral. Then it's still the same woman 3-4 years later, because they associated, they built up an association supported by, unfortunately, Stalinists, but still trade union. Yeah. So they had bad politics, but we did good things. So this trade union supported them. Trade unions are incredibly important. So the trade unions support them. We've seen them 3 years later standing up in Germany and saying, we want justice. It's not about money. It's yes, also, but it's good justice. And we want justice. We want justice. We want justice not in this case. We want justice and fair and secure labor issues in the textile industry in South Asia. So that was then the turning point. So then we were able to make the point. And actually, this case was then one of the major examples in the discussion in Germany about the supply chains law and the due diligence obligations for companies. And it was a game changer in that regard, because people felt empathy then. Because there were real people talking to them, giving interviews, they were covered by television, by radio, and that was so exciting and important.
So, but how was Germany part of them? I mean, how is it that it could be a case in Germany when it was a fire in Pakistan, in a Pakistani factory? So where was the German implication list?
A German company.
I see. It was a German.
It was a German company.
The parent company.
The parent company was. Yeah, of course. What we of course, the whole process of economization is to outsource political, economic, and also responsibility.
Yeah.
And so we try to reverse that process to some extent. Successful. And that's how you want to phrase it.
Yeah.
So it's a very fragile process. But the interesting thing is, when we started our enterprise in Berlin, ECCHR, we went to the trade unions, we went to lawyers, we went to European lawyers who were involved in the torture and crimes against humanity case, and asked them, we want to build up an organization which not only deals with torture and crimes against humanity, we also want tackle and corporate actors, build up a section, but you want to participate. But then the trade unions said, our members are Germans. The lawyers said, we're getting money from our government, that probably the fetus billing. It was actually a confirmation of Bengi's and Matomutua's critique towards Österreich. And that is, it's also something I want to really reiterate. This process, it's not the end of the story. That was in 2008. And so since then, now, there is this, of course, legitimate critique towards Amnesty International and Human Rights Watch. And they are now into this. They reversed their politics. Late enough, but they did. And the trade unions are now driving actors in this process.
Right.
So you can change things. And things have changed. And things have changed without this company.
Yeah.
That's also something, if it's on corporate accountability, due diligence, supply chains law, is it international criminal law? And I could bring other examples. This country was not the upholders of the liberal values and human rights. They were not involved in any of it. Probably not some, I don't want to exaggerate, but in most of as I recall, in most of the progresses of the last 2.5 decades, we were not involved. And this is why we were also like, look, yes, we were kind of prepared what's coming, but we were also not too afraid before, let's say, January, and I come back to that. So, but I said this was contradictory development. On one hand, very vivid and dynamic scene, young lawyers, female lawyers in South Africa, India, Pakistan, and basically you can go to all the country, and they also were set up teams of lawyers, environmental lawyers, human rights lawyers, and they work with the communities. They had different approaches, they had different tactics, they had different tools, but we exchange in the same kind of networks. That was the good thing about the development of the last, let's say, 20 years. Bad thing was how the erosion of international law, and that is you can point to both. The erosion means obviously it's a different China and Russia tortures, because they never claim that they wouldn't torture, or it's the US torture. And so the US systematic torture after 9/11 is an absolutely crucial fact, as well as the Iraq war from 2003. And it's incredible how people forget this war when they talk about Ukraine. Maybe they rightly talk about Ukraine. They rightly discredit and hold Russia accountable. But how can you talk about the war of aggression and not mention the 2003 war, which cost around about 1 million lives of Iraqis, and left a destroyed country where many other crimes have been committed afterwards? And that is also something I want to reiterate. We never had really any illusion about the US and their role, because we are aware of what they did. But let's come to the current development. And the current development, my feeling is, I really would like to discuss, we are facing a series of disruptive events, starting with the pandemics, then Ukraine in 2002, Gaza in 2003, and now Trump, which is really difficult to digest. It's difficult to understand, and it's difficult to find counter strategies, because we are all puzzled by what is happening. What we can say is, in none of the events things turn to the better. There are a lot of reasons to think that things turn to the bad. And I mentioned COVID because I see it through the lens of human rights. So it's a buzzword, vaccine apartheid, but it's important because in many parts of the world, people felt alienated from the rich Western countries, because they had millions of vaccines reserved. They didn't want to give up patents, and people died elsewhere. And that created, even in countries who were allies, mistrust. And that mistrust was then again came up in the Ukraine and in the time for the Ukraine war. And then, in Germany, the officials are wondering, why is not everybody at the UN voting on our resolution condemning Russia? I said, because you could have mentioned the Iraq war from 2003, and then people might have had a little bit of more understanding, and you could have had a little bit of more empathy, because these countries just went through a serious pandemic, and a little bit less lucky than you. But they didn't get it. And then Gaza came, and Gaza, of course, is on one hand a game changer, and on the other hand as well. I say on one hand because in this country it's obvious, but also part in my country, it's part of the series of incidents which led to bringing spaces for civil society actors, oppressing protest and leaving Christians. And also writing and events and everything. On the other hand, and that is also then giving me hope for now in the situation like now. I mean, you cannot underestimate the South Africa complaint against Israel at the International Criminal Court. People all over the world watched the hearings in The Hague, and they saw how really strong the South African mixed international legal team brought the case. It may not win, but it shifted to many parts of the world, including parts of our society. It shifted the paradigm around the Gaza war, and I think that is a big success, and that is also a major shift, because South Africa and other African countries. They were stuck in the critique of double standards. That International Criminal Court is only built to prosecute Africans. Many of those who lamented like this were themselves targeted by by prosecution, and so they said it in self-defense. But even South Africa played a very ambivalent role. So South Africa, using international law and the way they used it in the Gaza case at the ICJ, might be a very, very important perspective for the future. Although I keep on saying that BRICS, and Brazil, Russia, India, China, and South Africa is not funded. I mean, there is no political program which is anyhow progressive. It's something else. It's something else. But so we cannot align with BRICS. You know, we can partly agree. We've been partly cheer to what they're doing, but we cannot align with them. That's very clear. So, concluding, coming to now, bringing spaces for civil society, that's a serious thing. And that is stopping the money, stopping the financiation. And actually, there is an authoritarian playbook. Many people have already written about it. There is an authoritarian playbook, and shrinking spaces. It's no more just killing a lawyer or for whatever. No, it's taking them the status as a non-profit organization, stop the financing and from foreign agents laws, financing foreign and withdrawal. So it's all kinds of tools, and it's becoming serious. I don't know, others might assess that better in this country, but it is already serious also in my country. And that it's very clear it's going to be a hard time for civil society actors everywhere, because of the authoritarian playbook, but also because of tendencies in countries which don't follow the authoritarian playbook, like Germany. In Germany, political scholars in the tradition of realpolitik are actually calling for a return to the Westphalian system. The states should regulate these affairs amongst each other, and so and the stronger states, the powerful states. So what we had before, the standard of international law, of international criminal law, offered firm for critical voices from the smaller states like Liechtenstein or Vanuatu and all the others in the climate cases that were so important. Small, tiny countries, with smart ideas, with smart takes. And this stage will be closed. And this stage will be closed for us, or for NGOs, when we act as stupid as we acted in the last couple of years. And so the shrinking space for civil society, but also frontal attacks against institutions. And that is, of course, the pronunciation of many UN agencies, which depended on the US. But at the same time, the UK, Germany, and others are increasing development aid, and they don't step in because they are not spending the money in military. But it's also the sanctioning of the ICC. We don't know. My only hope is that Elon Musk lays off so many people at the Justice Department that they won't be able to really follow the sanctioning. I don't know. I mean, I have not a real judgment about the level of disruption which is going on, but my hope is that it will be so disrupted that they cannot really carry out their oppressive measures. But what I wanted to point to, which I have also read, is that the U.S. left. There was some kind of accountability mechanism for Ukraine and for the war of aggression of Ukraine. Of course, it was a master example for instrumentalistic use of international law, because they didn't want to abolish war of aggression. They didn't want to hold everybody who's committing a war of aggression as legal war of aggression. No, it was targeting Russia in the Ukraine case. But the U.S. left this mechanism on Monday, and I think that's a very significant symbol. So they are not even, when I said before, what we are doing is to apply international law in one case and then try to universalize that experience and apply it in many other cases, this door might be closed. And so the question is now,
You mentioned that the U.S. that Monday. Are you on a specific? Can you?
Yeah. I'm very bad in remembering every acronyms. There is an accountability mechanism, if they entire Google it, accountability mechanism for accountability group, working group, accountability for the war of pressure in Ukraine, something like that, and they left it. And I think that's very significant. So, there was this New York Times author who would call, I think 2 weeks ago, Trump's foreign policy, Neanderthaler realism. And I think that's quite significant. It's not realpolitik in the Kissinger sense, which was already quite bad for many countries in the world. No, it goes beyond, and it's the right of the powerful. It's what we watched when Zelensky visited the Oval Office. That could be the future if we are not done. If we are stuck in this resignation and impression, I watch and cynicism. Many leftists. A friend of mine wrote a book on rule of law in Germany, and it was more about the treatment of migrants in Germany. And they said one reason why they were able to push, so many bad laws and to try rights for migrants in Germany was the leftists was always ignorant about law. They had this cynical community. But, maybe now it's too late, but probably it's never too late to defend the rule of law, to defend core human rights, to defend international law. At the same time, we're always capable to criticize it. There is a valuable feminist critique, there is valuable decolonial critique, there is a valuable anti-populist critique, but we should evolve from the critique to the reconstruction of international law, and we should open it, we should be part of those who establish access to law for everybody, and that would be my proposal, and that is what I wanted to throw into this discussion.
Yeah, thank you so much. Thank you. I think we did that with present day dilemmas back to the issue of international law and the double standards and implementation. So I had a lot of thoughts going through my mind, but let me open it to the audience for comments and questions. I hope you'll make some comments as well and not just direct questions. So there's Sean. I'm sure you have a question about South Africa.
It's kind of related. I like your...
We'll stand out.
Sorry.
Hard to see you.
When you said about Gaza, you said that Gaza was both terrible in a way it limited the possibility of civil society, but then you saw some hope. And then you sort of dismissed the BRICS. But I'm sort of curious as to can you say, because China's used its own platform in some of these forums to be way more outspoken on Gaza and on various other human rights issues. Now, we can debate as to whether it's just bluster or not. But can we say something about, I don't know, is there any potentiality beyond, like as you said, I agree with you. BRICS is not something, say, if you're a leftist, I suppose, or progressive, that you would endorse. But is there something maybe there in some of the pronouncements with China? And then the other thing, which I'm actually more interested in, is the Hague group. Do you have anything to say about this? The Hague group that South Africa and a number of other countries were meeting together, and they made it explicit that their intention was to isolate Israel diplomatically, economically. It's kind of sort of like the way South Africa was isolated during apartheid. You can say something about that.
Yeah, the short answer is yes. Because, and of course, why shouldn't we advocate them? Why shouldn't we lobby them? Of course. What I wanted to say is that it's not a political ally. I mean, as the US, I'm sorry, I'm speaking for myself and for my tiny organization and for our leftist networks. The US was never an ally for us, the political ally. No, but of course, we could meet the former ambassador. I don't know, I forgot again the right title. I call her the ambassador for war crimes, which is definitely one, Wolfgang Kaleck, who was very supportive in the process of accountability in Syria. Why wouldn't we meet her? And we did the Syria cases, although the German government supported us. I mean, not financially, obviously not. We wouldn't have taken the money, but they liked our cases. But it was fun because at the same time, they liked our Syria cases and they speak, their conferences, they invite us. And then we meet the same people in the bombardment, which the German colonel ordered in Kunduz in Afghanistan, where over 100 civilians died. They meet us in court. So they cannot bash us. They greet us frankly. And they would it's interesting to play with that. And that is exactly, what I would propose. And obviously, we have to speak for many reasons. For many, many reasons, we have to speak to Chinese actors. And also, China is not only the Chinese government. I think China has educated more international lawyers than the rest of the world in the last decade. And that should be interesting. And that is something, for example, my friend Morten Bergsmo does, based in Florence. He is bringing Chinese, Japanese, Indian, Indonesian, Russian voices into his compilations. That is, of course, fruitful. Going back and forth and trying to influence debates there, but also giving them the floor. But political ally, no. Yeah. And I mean, like you refer to the boycotting Israel. Look, I think what strengths and it's my own view, and it was, you might be the different opinion, you might act in a different way, but I speak as a German-based actor, and it was incredibly important to strictly refer to legal categories. It helped to rationalize the debate, So we are not talking no longer about the moral right of Israel, of self-defense or defense or whatever. But we left the sphere of moral categories. We said, no, look, law provides some really interesting methodology to see if a certain set of facts is happening. We can look at legal types in the law, and when they are fulfilled, that's a kind of objectivity and and I'm not saying that it's objective, and I'm not saying that it's a truth. No. But it's more rational, and then you end up in a minimal consensus that no serious international lawyer denies that Israel is committing war crimes as well in Gaza as on the West Bank. And that's an important point. And that is actually, I think you mentioned our Gaza, our cases against the German government trying to prevent them from delivering arms to Israel. And it was very interesting. You might be surprised, Germany hasn't delivered war weapons in the last period. War weapons. I'm not referring to components of like motors or something like that. Real war weapons they didn't deliver. We cannot judge it, but we government sources which are quoted say this is due to the complicated legal situation. Means they are aware of the fact that it might be aiding and abetting war crimes. And I say it only once, and you might do whatever you want, but there is no hierarchy in international with international crimes. War crime, crimes against humanity, and genocide. It's although one might think that genocide is the crown. No, it isn't. It isn't. war crimes are as serious, are the case as we saw in the arrest warrants against Netanyahu, are as eminent, serious as genocidal crimes against humanity. And the delivery arms to war criminal is a crime itself. And that is something that the apparatus in Germany is discussing. And they wouldn't discuss it if we would have stuck only in the moral discussion. Then, we always lose, at least in Germany.
Yes. Thank you very much for your talk. My question goes to the politics around the election of judges. You mentioned that your core job with the organization is litigation, and you said that it's not just about how the court decides the case, but also everything that is possible on the stage that a court proceeding is. And it seems to me that it's extremely important who sits on the bench while this takes place. And I also think when you ended with this call for defending the rule of law, that when we look at the United States at the moment, there seems to be a bit two sides of it. One is that while everybody's looking at the respect for the judge's order in the case around the deportation of Venezuelans, this rule of law seems to be the last frontier. But on the other hand, when an authoritarian takeover also goes into the courts, then at some point there can be no longer a formal reliance on the rule of law, because if the judges are actually just doing what the government wants, then of course rule of law is not what we would want to call for. So part of my question is, I always wonder why there's so little politicization around the election of judges also to international courts. And this is something that you, with your work with ECHR, have ever encountered or worked around. And how you view also the dealing with, let's say, an authoritarian takeover of the judiciary.
Thank you very much for clarification. Of course, I'm not one of. Rule of law means for me the corpus of constitutional principles, the corpus of human rights principles, etc. And it doesn't mean an abstract rule of law without that content. So, and that would be then the case with an authoritarian takeover. And so, very clearly, yes. And then you refer to, of course, to a very important development. That's all kind of court packing. You saw it here, very successfully carried out by Trump in his first term, and not very successfully carried out by the Democrats, which you also see in other countries, that you see that the European Court of Human Rights. We suffered from that. It's the states who nominate the judges. So you have a conservative government in Spain, and they name two fascists and one Opus Dei member, and so the Opus Dei member is best of the worst. And then you end up with having an Opus Dei member in the European Court of Human Rights, probably not even anyhow, experience in human rights law. And actually, we suffered that a very lot because we won almost courtroom case, and when it comes to migration, when it comes to pushbacks and to collective expulsions, that was a case of pushbacks at the Spanish-Moroccan border. So we lost the case. We won the case in the first instance, and anonymously the conviction. The court, all judges said that was lawful. And 2 or 3 years later, the political climate changed, and they decided the other way around. And so it's very clear that this is also why, you should. When I say progressive use of law, that doesn't mean, we file a case and we trust you, judge. We trust you, court. No, that's not the case. We file a case, and at the moment when we file the case, we argue in an understandable language. Hopefully, in some cases we're successful. We try to explain with what this case is about, and we try to achieve, some steps towards justice on the way from this legal to this gentleman. And when we sitting on the judgment, we still work with the case. We work legally, we work within the legal community, we work in the discursive sphere, but we, if possible, That's a question of resources. That's a question of political opportunities. We work with other actors outside the court building, and that is very well enshrined in E.L. Weitzman's forensic architecture concept of forensics. Forensics refers to the Roman Forum, and he reminds us that forensic sciences is now restricted to, serving the court, serving the legal proceeding. But the idea was there are certain affairs, there are certain topics which need to be discussed with public forum. That is our thing. So we have to be capable. We not probably, not me being at the same time the lawyer and then the loudspeaker on the marketplace. No, but we as a complement network of complementary actors, we have to be able to bring a serious professional court case, but at the same time work together with documentary filmmakers, theater people, or people who bring in the communities and work with them and people advocacy, or can use the fact that we brought the case as a kind of icebreaker, as a kind of creating a new opportunity which wasn't there before.
Just kind of a complementary question to this on the international context. If the problem is like court packing and judges and legality in this international intergovernmental institutions, how can we defend the commitment and legitimacy of this, even the ICC, if you like, to which, of course, depends on who is there and which then becomes politicized in the same way that all either government or institutions are politicized in terms of international geopolitics. So what are the ways in which we can somehow fight against them?
I have problems with the term politicized because, I have problems with the term politicized because all the affairs we're talking about are eminently political, and so and they take place in a political context, and there is no way to claim that we also speak out against this notion of neutral objective law, which is like a subsumption machine where you put in a case, then the judgment is put out like a judgment factory. No, that's not.
Yeah, I think what I mean is really taken over by national interests on the concept government.
There are always interests at stake. So, we have to analyze the situation to spell out what interest what is behind.
Yeah.
And sometimes we are litigators, and that already don't underestimate the other resources and the efforts which go into professional litigation. And we creative, professional, with very little resources. So we have no capacities to then also look into the the election processing of judges. That has to be done by others. So this is why I say we have to work with everybody, in his or her role, And so some people within the apparatus, I'm not declaring the whole apparatus for corrupt, or it's partly corrupt, but there are definitely. But there are people who are good handling in good faith, and so we have to reach out to them, we have to talk to them, and they have to be part of the conversation. And of course, if necessary, we have to criticize the GRP, the Court of Human Rights, as we did in the pushback cases, which are, from our point of view, legally really standards. And it's only explainable because of the anti-migration climate in Europe.
Here, yes.
I'm speaking Kantian ideology on the perpetual peace, that if there will be constitutional democracy at the holistic level, it will create, cumulative effect that will be peace at the international level. But recently, some of the constitutional democracy in West in the world have realized, violence and huge international law in very, negative manner. So my question is this, that do you think that there are two forces? One is political forces, the other one is capitalist forces. And unless and until there will not be balance between these forces at the global level, there cannot be meaningful in the international law. I see like European Union, there is like a comparatively better balance between capitalist forces and political forces. Like capitalists cannot do anything what they want. There are very robust civil society, the academia, parliament, and so on and so forth. But when we see US, we see a very extreme kind of capitalist groups, and they are trying to, rob with political forces and so on and so forth. So how do you think that international law can be a robust, mechanism to address the balance between capitalist forces and political forces? I've been talking for very long, and I don't want to. It's a task. Let's say that, and it's a challenge. It's when I say, and that was also to you, Sean. The problem with any alliance between, let's say, European states and these bearable, global southern states, which is difficult to define. Is India, how would you assess India with Modi's nationalist authoritarianism, pressing minorities and also opposition? But if you want to, let's say, talk to the Latin American states and leave out Malay kings, if you want to talk to the Latin American states and if you want to ally with them, you would need to come to another global economy. And that is the problem I see. That is the problem I see in the establishment of real international law. That you cannot create international law as they thought they can do it for the last, 80 years since 45? 80 years without thinking of a fair world economy, and you cannot talk about just transition, when it comes to climate, without a proper, let's say, not dogmatic, but without thinking about reparation for colonial and environmental damages. And I don't mean to bury the European states with debts. That's not the tip. But if they would at least, release the debts, the foreign debts, at least half of the countries of the world which are suffering, which are still paying on debts from whatever, that would be an important step. And I don't see that. So, balance between capitalist and political, no, that wouldn't be my categories. I would say, if we really, of course, one end defending that a minimum standard of international law is the order of the day. That's very clear. On the other hand, when I look into that's the concrete. The utopian vision is that someday, the consciousness grows that this is one world, this is with one world climate, which affects different parts of the world in a different way, as unjust as his world economy is, but still, it's bad if we cannot get it handled in a thoughtful way. This world is going to be destroyed, as well as the next pandemic, which is most probably coming, and this country is doing its best to support that development. And that's another example. Wonderful Mike Davis wrote 25 years ago this book on aviation fuel, and he says we're going to face a pandemic, and the tools to condemn pandemic is the UN-led Agency for Vaccines. What do we have? We have private corporations which earn a fortune from public money developing vaccines. Happy that they did it, but still, when profit could be a little less, and that make you noise, and then take the profit and distribute the next. And the second thing is he said, and that will hit this country, that was our countries in Europe. This kind of pandemic or maybe other diseases will hit us unless every country is equipped in the same way with a robust health system. So it's not enough in times of globalization. It's not enough to protect New York City and the state of New York and this country. No, you have to be aware that you are as vulnerable as the weakest part in this chain. And that, I would say, is a vision I would develop, and not necessarily balance between political and capitalist forces.
Well, yeah, yes. Hi, I posed one question and maybe one comment. I think first my question, so you described the Pakistani cases and some criticism around like choosing the right forum or when to take that case. And that kind of reminded me of a case that was litigated in the UK a couple of years ago about the Fundão dam from Brazil that broke and left massive environmental damage. And at least a lot is litigating in the UK did so on the basis that Brazilian substantive law was going to get to bring the case with a foreign. They had the thing was taking very, very long, and that would be better in the UK, so they brought it to the parent company there. I was kind of wondering, like, do those considerations play a role? Like, how do you go about that? So one is bringing contact of civil society in the place, whether you're planning to lead in or not. And secondly, maybe more common, I think what you mentioned about cynicism, about using the law, that really spoke to me because I've thought a lot of that, I think, recently, but also just, seeing like really nice examples of creative learning to go about that. I think maybe just a nice example to share. In the Netherlands, there's a criminal lawyer ability to fit to brought a criminal case against the CEOs of Schiphol, Transavia, Ryanair for assault because the noise that these airplanes make would constitute the legal threshold for assault. It's also an acknowledgement that like if you sue companies that find nothing to them, so she's using the criminal law to like bridge that public-private divide, corporate zone, go after them directly. So I guess like I could relate to what we were saying about just also using the law.
Definitely. No, thank you very much for the comment and coming back to your question. That is obviously crucial, and that is also partly decolonizing the practice of international law. Means that we have to be aware that we in Berlin, New York, and similar, parts of the world are privileged, but that shouldn't prevent us from sitting down from people from less privileged countries in less privileged situation and try to make everything possible to carry out this kind of lawsuits in a kind of eye level. But this is also buzzwords which now has to turn up in applications to formulation. So I hate it. No, I mean like they want you to include certain buzzwords, and that now cooperation on eye level is a buzzword. But it still makes sense. Still makes the idea makes sense to acknowledge that, and that is something I love more. Friend of mine, Iranian French sociologist, Shora Makaremi, in Paris. In her writings, she says, she writes about the killings in Iran, the Mujahideen, the 10,000 Mujahideen and leftists were killed in the 80s and late 80s. So she says, in the process since then, we, the family members, the torture survivor, became experts. And I think that's also very, very important to acknowledge. Yet, the definition of expert, and who you allow to frame him herself as an expert. So that's absolutely crucial. I mean, the other side does it every day. So, we're sitting there, and this is the law professor who writes the legal opinions for the corporation. He is an expert, and I'm the human rights activist. I don't allow that. I don't allow that. No, I'm an expert myself. But then, my task would be then talking to you and talking to him, who work with communities. You have another set of expert knowledge. You are experts as well. And that has to be acknowledged, and that is not acknowledged in all situations. And one of the problems, this problem will be after 10, because there will be less financiation for human rights litigation in the future. But it was a serious problem of the last decades, that the foundations and finance this kind of litigation were deeply paternalistic and were actually dictating NGO communities and networks, for example, in India, not to litigate this set of cases, but they financed another set of cases. Don't attack the Modi government frontally, but do something on religious discrimination or whatever, And that is something we have to learn. And that's also something we have to be aware of. It's a constant learning process. Decolonization in practice is a constant learning process. We will never succeed, and it will always be an imbalance between us, with our privileges, being more or less secure out on our workspace, and people who carry out the work in other part of the world. But it shouldn't prevent us from, and that's the important point. We must invest money and resources, bring all actors on the table, and to strategize from the very beginning. Then you find out the different needs, the different desires, the different capacities. And what we often have is that when we discuss this with communities, with local actors, it's clear they're not equipped for litigation, in particular not for year-long litigation. But there are other tools, and that is also progress. There is a lot of complaint mechanisms, so-called soft law, we would say emerging law, complaint mechanisms, where you don't need a year-long litigation. You go there, file a complaint. Of course, a serious London and Manhattan human rights lawyer would say this is not litigation. Litigation is only where litigation is written. So soft law is not litigation, but this is why I say we have to overcome this restricted understanding of litigation and phrase it as intervention, as legal intervention. And legal intervention can carry it out in different ways, through litigation, in year-long proceedings. That might make sense if you have the right constellation, but sometimes it's better with a certain community. You work 6 months apart, you file a complaint, well thought, professional. You bring them to the home base of the corporations, and then that's over. And that's you can estimate the efforts. It doesn't cost too many resources, but that is something you have to discuss with them. And that is a long and also frustrating process. And that you have also to take into account. I was saying partner. Of course, no partner. Yes, sure. We partner all the time. But, what is the most frustrating? It's the partners. On every partner, it never works out. That is also something you have to take into account. But there is no choice but to partner, to ally, and trying to use to make use of all the different knowledges, sets of knowledges which are at the table.
I think we have time for just one more question. So, maybe we'll take those. Yeah, Mara and Julian. I was interested. I mean, obviously, I know that we're talking about international law, but I was interested on the relationship between tensions in domestic law and what lessons you draw from your experience in international law, specifically within the realm of democracy. And I feel like we talked a lot about either Western interventions and aggression or developing country context. But I wonder, so on one hand, like I see an increasing sort of misuse of the law, if you will. Like you mentioned, the EU like pushback policies that are obviously not well aligned with like any standards of human rights, but also the increasing oppression against like civil society actors that are, like now prosecuted, if you will, as domestic terrorists, both in the US, but we've also seen it in Germany in the like climate space. So like how when does this like get to a point where you would say, hey, it's necessary to intervene through, or like to try to intervene through international law rather than rely on the function, like the presumption that, in these democracies, the domestic legal system is functioning. And then also my other question, and I think that is like very much still undergoing and in development, but I feel like in the US at least, we increasingly see that the administration is, like bluntly speaking, just completely ignoring legal standards. Like a lot of actions that are taken under the Trump administration are just unlawful. So I guess as a like international lawyer, in a way, like unfortunately you must be like used to that, so I don't know if there's any lessons you can draw on researching in you then.
Yeah, I would say, I think Friedrich Merz recently said that he would not comply with that international arrest warrant. And you said previously that the German government was quietly saying, we can't actually deliver these arms, or at least like final delivery of the weapons to Israel. So is there a contradiction there that maybe will be unearthed? Maybe it's not Friedrich Merz's decision, or maybe it's some local police official or state police official who will be presented with a conundrum to violate that arrest warrant or not enact that arrest warrant on if he does visit that.
Yeah, to start with your question, because my memory is short. I mean, Friedrich Merz is a former BlackRock manager, who has no experience at all in governing, not a province, not a country. So let's say that's a lack of experience, and let's say that we're not trying to edify nobody, but let's say that the level of critique we receives, also from mainstream lawyers, brings him to some enlightenment. I mean, there was an article in the Spiegel, the main news magazine, by let's say mainstream international law professor, who normally is, in line with the government, and he would say the title was "We have to defend international law against Putin and Trump," and then he comes to the international, he get to the ICC arrest warrants with Netanyahu. And he says, this is undermining the legitimation of the ICC at the time where the international can toward and for the other international leading institutions need support. That is more or less the line of international law professors, even those who haven't supported our US torture cases till the beginning. In retrospective, they would, in the moment when it's hot, they wouldn't. And so that gives me the hope that we can, that this is not going to happen. And it's also like, it's very symbolic. It's all around East Germany then. Well, I mean, they act stupid. It's a speculative question. And, one could say, yes, if Putin travels from Mongolia to South Africa and then to Algeria, will Germany file an arrest warrant and ask Algeria to seize Putin? Why should I answer this question? Should that be the answer? We comply with law, should it be the answer? A very abstract answer, but they didn't. And so now we have this discussion. I can only tell you, but we have already the complaints written. So we will file cases, obviously, or make this, but I'm a player that I'm not betting in public. I would bet that there will be no invitation from the candidate. It won't be, because there are still some lawyers in the US, in Germany around. They would say there is no way not to comply. There is no way. There is no way. coming to your beloved, or maybe you are not from here, but this beloved country and lawfulness. Yes, I have some experience, but that was 20 years ago. When this country set up a systematic torture and extraordinary renditions and invaded Iraq. And that is something people tend to forget. I mean, it was never a nice world. It was never a nice world, and this was never a law-obeying country. This country was always involved in the history of this country is a history of committing international crimes elsewhere, being complicit or being explicitly invading other countries, overthrowing governments. The question is, how much does civil society, how much does the apparatus allow? My genuine surprise when I came here as a German lawyer to work with the Center for Constitutional Rights, CCR, in these cases. We fight universal jurisdiction cases in Germany, in Spain, Belgium, France. And my surprise was, I was also, I felt like, do they search my documents? What is going on? And then you run into this conference, Columbia, where you see uniformed West Point officers who are basically saying the same as we do, condemning war crimes, And then you end up in the ASIL association, what it's American Society for International Law, Washington. I sit down at a panel to explain the torture cases, and then this gentleman approaches me and says, "Oh, you're Wolfgang." I said, "Well, yeah, I'm Jim." That's the guy from the Minister of Defense, and he says, "Oh, you got a strong case," and and then you see also the level of documentation which has been made possible by investigative journalists, by Freedom of Information Act litigation, but also by whistleblowers. And you see how important all of this is. And my motivation comes from a kind of success story. Success is, it's a bad word, because success in the light of torture and disappearance is shitty, but it could have been worse, and that might be our task to prevent it from being made worse. And so the idea of the Bush administration was to establish the model Guantanamo. When the model Guantanamo is, you have an island and there is no access to justice, when you put people there. And they wanted to establish it. And this didn't work out because, and that's then where the BRICS come into play, and all the others who are, of course, hypocritical as they all are. I mean, Abu Ghraib was used by Saddam Hussein in the cruelest, incredible way. All the neighbors, all the neighbors from Iraq are torturing people, but they all condemned U.S. torture. Abu Ghraib in Guantanamo became a symbol, and rightly so, it became a symbol for injustice. And it helped at this point to disapproach from the model of that way at Guantanamo, and to distribute, to further disseminate the idea that torture is anyhow the right tool. And that was due to the resistance of, let's say, global actors, including civil society actors and people from the apparatus here. And that is probably, well, I'm incapable to assess current situation here, but it could be probably the medicine for now as well.
Cool. Well, I think that it has done our time a little bit over, but thank you so much for this very wide-ranging set of comments, but all centered around was issue the way double standards in international law. I forget this simply about that. But thank you so much. And And really happy to be having this collaboration with Rosa Luxemburg this week. Thank you. And thank you all for coming and for the wonderful photos.